Restrictions on the freedom of association. Restrictions on the freedom of association. The right of association, like other individual freedom, is not unrestricted. Clause 4 of Article 19 empowers the state to impose reasonable restrictions on the right of freedom of association and union in the interest of public order or morality or sovereignty or integrity of India. It saves existing laws insofar as they are not inconsistent with fundamental rights of association. The Criminal Law Amendment Act 1908, as amended by the Madras Act 1950, provides that if the state government is of opinion that any association interferes with the administration of law or with the maintenance of law and order, or that it constitutes a danger to the public peace, it may, by notification in the official gazette, declare such association to be unlawful. Such a notification was to be placed before an advisory board. Representation against such a notification could be made. If the advisory board was of opinion that the association was not unlawful, the government was to cancel the notification. The validity of the above act was challenged in the case of State of Madras vs. V.G. Rao, AIR 1952. The Supreme Court held that the restrictions imposed by Section 16, 2b, of the Act were unreasonable. The test under it was subjective satisfaction of the government, and the factual existence of the grounds was not a justiciable issue. Therefore, the vesting of power in the government to impose restriction on this right without allowing the grounds tested in a judicial inquiry was a strong element to be taken into consideration in judging the reasonableness of the restrictions on the right to form association or union. The existence of an advisory board could not be a substitute for judicial inquiry. In Haji Muhammad vs. District Board, Malda, AIR 1958, a restriction requiring a teacher to take prior permission to engage in political activities represents to be a reasonable restriction. It aimed at preventing teachers from getting mixed up with political institutions. For a teacher is not merely a citizen, but he has to be under certain terms and discipline of employment. But a government order requiring municipal teachers not to join unions other than those officially approved was held to impose prior restraint on the right to form association and union, which was in the nature of administrative censorship and hence invalid. In G. K. Ghosh vs. E. X. Joseph, AIR 1963, Rule 4-B of the Central Civil Service Conduct Rules 1955, which requires a government servant not to join or continue to be member of the Association of Government Servants as soon as recognition given to such association is withdrawn, or if after the association is formed no recognition is granted to it within 6 months. In other words, the right to form an association was conditioned on the existence of recognition of the said association by the government. The court said that the condition of recognition made the right under Article 19, 1c ineffective or illusory. If the association obtains the recognition and continues to enjoy it, government servants can become members of the said association. If the association does not secure recognition from the government or recognition granted to it is withdrawn, the government servants must cease to be the members of the said association. Under Article 19, 4, reasonable restrictions could be imposed on the right in the interest of public order, but in the instant case restrictions were not reasonable as the recognition could be refused on grounds which had no connection with the public order. In Balkotia vs. Union of India, AIR 1958, the services of the appellant were terminated under railway service rules for his being a member of Communist Party and a trade unionist. The appellant contended that the termination from service amounted in substance to a denial to him the right to form association. The appellant had, no doubt, a fundamental right to form association, but he had no fundamental right to be continued in the government service. It was, therefore, held that the order terminating his services was not in contravention of Article 19(1)(c), because the order did not prevent the appellant from continuing to be in Communist Party or trade unionist. The right to form union does not carry with it the right to achieve every object. Thus the trade unions have no guaranteed right to an effective bargaining or right to strike or right to declare a lockout.